Good morning, this is your Kelso Report for Wednesday, November 21st. I'm your host, Clark Kelso. We begin today with two evidence law cases, the first involving the admissibility of scientific testimony, and the second about testimony from the foreman of a grand jury. Our third case involves absolute prosecutorial discretion, and we close with a tax and a revenue decision involving the County of Los Angeles. There frequently is a conflict between the methodology by which science moves towards truth and by which the courts find truth. And as a result, special evidentiary issues can arise when so-called scientific truths are admitted into evidence. In Barabin v. Aston Johnston, the plaintiff sued after he developed mesothelioma, claiming that his illness resulted from occupational exposure at the paper mill where plaintiff worked. According to the plaintiff, the defendant manufactured dryer felts that contained asbestos and that were installed on the paper machines used in the paper mill. The jury found in favor of the plaintiff, and the trial court entered judgment on that verdict. The Ninth Circuit vacated and remanded for a new trial, because the trial court failed to conduct an appropriate evaluation of the plaintiff's expert's testimony under the Supreme Court decision Daubert v. Merrill Dow Pharmaceutical, 1993 case. The expert planned to testify, among other things, about the results of certain experiments he had conducted with dryer felts containing asbestos. Now, because scientific testimony can be so influential in a case, the trial court has a special gatekeeper function under Rule 702 of the Federal Rules of Evidence. Under Rule 702, the trial court must make a preliminary determination that the proffered expert testimony is sufficiently reliable and trustworthy, an analysis typically undertaken using the factors identified by the Supreme Court in Daubert. The trial court in Barabin did not conduct any analysis of the expert testimony and simply let all of it go to the jury unfiltered. A clear error that resulted in vacating the judgment and an order for a new trial. The trial court in our second case also committed reversible error. This time the Ninth Circuit faced an unusual evidentiary question in United States v. Wiggin, where the trial court had admitted testimony from the foreman of the grand jury which had indicted the defendant of making false statements and perjury. The foreman testified, among other things, that he and other grand jurors did not think the defendant was credible or believable. Now, the long-standing rule is that a criminal indictment itself is not evidence against the accused and affords no inference of guilt or innocence. And pretty clearly, in my opinion, the use of grand jurors to testify, in essence, as to their opinion of a defendant's guilt and their reasons for indicting him is squarely at odds with that policy. The Ninth Circuit agreed and held that admitting this testimony was reversible error because its prejudicial harm plainly outweighed any probative value under Federal Rule of Evidence 403. Particularly since the trial jurors are likely to defer to the grand jurors' perceptions of credibility instead of doing what they're supposed to do, which is to make their own assessment of credibility. Next, we have a sovereign immunity case. The law is well settled that prosecutors are entitled to absolute immunity with respect to their decisions that are intimately associated with the judicial phase of the criminal process, where the prosecutor is acting essentially as an officer of the court. Absolute immunity is necessary to ensure that prosecutors are not subject to never-ending and harassing lawsuits. In Slater v. Clark, the Ninth Circuit faced a rather unusual civil claim for damages against Massachusetts prosecutors who had decided not to seek full extradition of a Massachusetts inmate who had been released after serving 15 years on a murder charge and fled to Washington. Just before his release, he had been arraigned for 2 incidents involving assaults on prison staff. He was released on his own recognizance on those charges, and that's when he, instead of appearing for a hearing on those charges, left the state to relocate in Washington. Massachusetts law enforcement agents asked Washington agents to locate him, and they did. But the Massachusetts prosecutors decided to request a limited extradition warrant that authorized extradition only from New England states, not from Washington, where they knew he was located. 6 months later, he murdered 2 people in Washington, and their personal representative and heirs sued the Massachusetts prosecutors. Well, the Ninth Circuit rather easily extended the doctrine of prosecutorial absolute immunity to the decision whether and how to seek extradition. As the court explained, because the decision whether or not to extradite a criminal defendant is intimately associated with the criminal phase of the process, those government officials are absolute immune from suits arising out of those decisions. Finally, we have a tax and revenue case from the Supreme Court of California. This was a big defeat for the County of Los Angeles. The California Supreme Court unanimously held in City of Alhambra versus County of Los Angeles that the county had unlawfully imposed tax administration fees on that portion of property taxes that were to be deposited in the county's Educational Revenue Augmentation Fund, or ERAF. In 2004, 2 different state budgetary measures were enacted, diverting local property tax revenue that would have been deposited into each county's ERAF to instead fund various state budget gaps. But the state otherwise made whole each county's ERAF contribution through the allocation of other state funds. There was some budget gimmickry going on. Well, the issue before the court was whether those state budget shifts meant that the collection of the ERAF funds was no longer exempt from the administrative fee. The County of Los Angeles wanted to collect that fee. Well, after examining the purposes of the diversion of the ERAF funds and their replenishment, the court unanimously concluded that the ERAF exemption from the administrative fee still applied, notwithstanding the 2004 budget legislation. For the City of Alhambra alone, this is about a $4 to $5 million win. So when you add up all of the cities in Los Angeles, you see a pretty big loss for the county. And that's it for today's Kelso Report. Have a great day in the law and a happy Thanksgiving.